People X Rel Barta v. Molina.
Good afternoon. Brooklyn Defender Services, Queens, formerly Queens Defenders, by Peter Barta for Appellant Shahid Gibson. I'm joined by my co-counsel, Matthew Thomas. I'm requesting 2 minutes for rebuttal, please.
Yep.
May it please the Court. From its onset and for decades, CPL 3032A has stood for the proposition that the defendant is entitled to release on her own recognizance if the prosecution is not ready for trial within 90 days. Respondents ask that this Court change the unbroken line of jurisprudence and allow such a defendant not to be released on their own recognizance, but instead placed on electronic monitoring.
All right, I think you know what we're going to ask. Is it moot?
So, I don't believe it necessarily is. The question of whether Mr. Gibson could be held in jail while awaiting electronic monitoring was live when argued before the Appellate Division and when this Court granted leave. And the issue was litigated and decided by the Appellate Division below. The Appellate Division ruled that the question of whether Mr. Gibson was entitled to release while awaiting electronic monitoring was moot because he had been released. But the remaining question, Mr. Gibson was on electronic monitoring when we were in front of the Appellate Division and was on electronic monitoring for 9 months after the Court ruled that he was entitled to release. And the Appellate Division ruled that our arguments were...
Is he on electronic monitoring now? I'm sorry, over here.
He is currently serving a sentence in state prison.
Okay, so there's obviously, so what relief could we give him? And this goes obviously to the mootness question.
I'm asking that this Court rule that electronic monitoring is not a just and fair, just and reasonable form of release under 3032A.
But he's not under that condition.
No, he personally is not. I don't think this Court has any relief to provide to Mr. Gibson personally.
So it's moot as to him.
As to Mr. Gibson, yes. I do believe that this falls comfortably under the mootness exception brought by this Court in Hearst, in that it meets all 3 factors of the mootness exception. It implicates a significant issue of liberty. It is likely to recur, and it will evade appellate review unless this Court takes it up.
So you're asking us to apply the mootness exception to reach the issue of whether electronic monitoring was an appropriate condition to begin with. Is that right?
Yes, and as to whether the Court erred in holding Mr. Gibson in custody indefinitely.
But I think on that point, the people already conceded that that was an illegal, we'll ask the people that that was illegal to begin with. But I have some concerns because I think during the entirety of this case, defense counsel acknowledged or sort of said, look, there can be electronic monitoring here. He said that routinely. He never challenged that electronic monitoring was not a proper condition. Do you disagree with that?
I do. He was me. So
okay.
I can't blame anything on anyone else. This has been my case from the beginning.
Aware of the underlying facts in the record. Fabulous.
Yes, good.
The initial position I took when I argued that Mr. Gibson was entitled to release, the first thing I said to the Court was, Your Honor has 2 choices. You can either release my client on his own recognizance, or you can release him on supervised release. And those are the 2, that would be on page 37 of the appendix, page 12 of that particular record. I believe my exact words were, I believe the Court's options are to either release him on his own recognizance or to release him on supervised release.
But
I
didn't
have
you
something
also
that said,
say...
I'm sorry if I can just finish up this thought. You said, I would not object if the Court were to release him, and then we can do the electronic monitoring outside. I have no objection to that. I don't know if that's possible. You said, we have no objection to electronic monitoring. I don't have the page sites for that. I'm sorry.
42.
No, I absolutely said those things, but I said those things after the Court had already declared it was putting Mr. Gibson on electronic monitoring. The Court's first position was that it was going to set bail. And then we had discussion where I explained that Mr. Gibson was indigent, that he would not be able to make any amount of cash bail, and that if the only bail that the Court had the authority to set would be bail that the defendant could afford, and because Mr. Gibson was in fact indigent, that bail had to be 0. Once we moved past the bail question, the Court said, I can put him on electronic monitoring, I'm going to put him on electronic monitoring.
But how is saying we have, over here, we have no objection to electronic monitoring, and I think also we certainly don't disagree that the Court has jurisdiction and authority to order electronic monitoring. How does that keep the question in the case before us.
Well, I believe that I was objecting to the imposition of electronic monitoring. My subjective belief in whether the court had the authority.
Wait a minute, the statement, "We have no objection," maybe I'm reading the transcript incorrectly, but if that's correct, that seems pretty straightforward.
It also seems to indicate that that statement was the product of communication, because the continuation of it is, we have no objection to electronic monitoring, but as of 10 minutes ago, which is the last time I checked. So this is not just you making an argument, this is the result of consultation with your client.
Well, Mr. Gibson was not present for that conversation, was not present for any of that record on either day. So I was unable to discuss with him. So I certainly would say that Mr. Gibson himself did not waive his right to be released. There was certainly no colloquy with him. He was not present. He did not sign any documents the way we typically have a client waive a fundamental right. So none of that happened as to Mr. Gibson. But again, any concession I made at that point was after the court had already declared its intention. At that point, I was trying to mitigate the consequences of the court's decision to impose electronic monitoring. If the court
Is
was
the
going,
electronic monitoring itself permissible?
I don't believe it is under 3032A. I don't believe that would be a just and reasonable form of release, because it's not a form of release.
But if that was your position, why not say, I want to preserve my objection for the record, but, and then move on?
I certainly could have phrased that more eloquently. I don't disagree with that, and I understand that would have made a clearer record. But at no point anywhere in the proceedings did we consent or request electronic monitoring. We opposed it. The position throughout the case was that Mr. Gibson was entitled to be released, 3032A, and that electronic monitoring was improper. There was...
Counsel, to go back to mootness for a second, we might apply the mootness exception and go through the factors and weigh them differently, but isn't our review here whether the appellate division abused its discretion in finding this moot? That's what we're limited to, right?
Well, I believe the question before the court is whether the court below, imposed a proper form of release. And I don't believe that
But the
3032A
court below
allows
found
it.
this was moot, right?
I'm sorry?
They found that part of this lease was moot, right?
They found, the only part of the decision that they found moot was that Mr. Gibson had physically been released and placed on electronic monitoring. As to all my other arguments, they ruled on the merits that those were not valid arguments. So no, I don't think that the court, the appellate division, found those arguments moot. I think they were litigated and decided on the court below, and we have appealed them because I think the appellate division decided it wrong.
So your view of the appellate division argument is they ruled on the merits of the question of whether electronic monitoring was a permissible condition of release on the merits against you,
Yes.
but nonetheless said it was moot?
So that was what the specific language of the appellate division's decision is that in light of Ms. Shahid Gibson's release on October 19, 2023, the petition is rendered academic to the extent that it seeks his immediate release. So the fact that he was not in a jail cell anymore, to that extent, the court found it moot.
Right, but I think there are two mootness issues. It's that first one, which we would look at to see if there was an abuse of discretion by the appellate division. And there's this second one, which you're asking this court to invoke so that we can reach the issue of whether electronic monitoring could be a
believe that's
condition at
correct,
all.
yes.
That's correct, right? So we have two mootness issues. So why on the first one do you think that the appellate division abused its discretion, recognizing that, that's a pretty significant statement to come from this court concerning a mootness decision by the appellate division?
I don't believe that, I'm not sure I understand the question. I don't believe the appellate division was wrong that the issue was moot as to Mr. Gibson's physical release from a jail cell. He was, the timeline here is that the court placed Mr. Gibson on electronic monitoring. I came back to court a few days later and said Mr. Gibson is still incarcerated. He has not been placed on electronic monitoring, which is one of the problems with electronic monitoring, is that it is not an immediate process. The defendant does not go from the jail cell to electronic monitoring. The defendant goes from the jail cell to a screening process by the sheriff's office, who may or may not find him eligible for electronic monitoring. There's a whole list of factors that the sheriff would have to find. And in the meantime, the defendant is in this limbo where he is waiting to see, am I going to be placed on electronic monitoring, am I not? And it's totally unclear what happens if the court orders electronic monitoring and the sheriff's office says no. I mean, obviously, I think my position would be that the defendant would then have to be released, but there's really not much procedure set forth for any of that.
Isn't the appellate division decision mainly on the 30-30 issue? Or
I'm sorry?
am I reading that wrong?
No, I don't think anyone in the appellate division had any problem with the decision that Mr. Gibson was entitled to release pursuant to CPL 3030. There were 15, 16 pieces
Seems
of
like that's
discovery.
what they addressed, right? They addressed 30-30. Where do you see in the appellate division them addressing anything else?
Well, I mean, to be fair, the appellate division's decision is very spare. But it does say that the petitioner failed to establish entitlement to any other relief sought, which I have to assume applies to the other arguments we made in our brief, because what else would they apply to? And I believe that the reason electronic monitoring is not a just and reasonable form of release on the merits of the question is because it's different. It's treated differently by the CPL in a variety of ways. For one thing, the CPL requires a showing that no other realistic non-monetary
Sorry,
condition.
just to go back to this appellate division decision, the last line of the appellate division decision is, accordingly, the petitioner failed to demonstrate entitlement to relief pursuant to 3032A.
I am not seeing that in the decision.
I might be looking at the wrong one.
Wrong decision. Withdrawn.
I was nervous enough already.
Okay.
See, it happens to everyone, counsel.
Fair enough. So as I was saying, the CPL lays out different conditions. Electronic monitoring is the only non-monetary condition under CPL 5103A that's limited in both what defendants it can be applied to and under what specific circumstances it can be applied. No other realistic condition can suffice. Defendant must be eligible and he must be charged with a felony, an eligible misdemeanor, or have previously been convicted of a violent felony in the past 5 years. It requires an individualistic determination on the record or in writing that electronic monitoring is, in fact, the only condition that the court believes will suffice to have the client returned. It must be unobtrusive as possible. No other condition has that kind of limitation. It can only be administered by certain entities, which is specified in the statute. There must be a de novo review of electronic monitoring every 60 days. The defendant must be apprised in writing of both the conditions of his electronic monitoring and the potential consequences of a violation. And as we argued in our brief, the legislature specifies that electronic monitoring is deemed custody for the purposes of CPL 17070 and 1880 because it is a different level of confinement than any other non-monetary condition. I see that my light is on, but I'm able to answer any questions. Seeing none, thank you.
Good afternoon. May it please the court. ADA Amanda Iannuzzi on behalf of Queens County District Attorney Melinda Katz.
Counsel, not to go back to this decision, and hopefully now the right one, but what was decided at the appellate division?
So the appellate division's decision, yes, it was very brief, stated that the issue of the defendant's continued incarceration was moot, as the defendant was no longer in custody, and that it would not apply the exception to the mootness doctrine. The final sentence of the decision is, moreover, the petitioner failed to establish entitlement to any other relief sought.
Do you think that's a merits determination on this electronic monitoring question?
It could be one interpretation. However, I would disagree that it is, because the issue here was that the appellate division in a habeas review was limited to the record before the trial court. And on this record, where the defendant affirmatively stated, we do not object to the imposition of electronic monitoring and acquiesced to the court's authority on that issue,
That wasn't before the court.
it was not before the court.
And can I just ask you real quickly, what are the contours of the concession that you've made in this case? What was illegal?
The issue that we conceded on is the issue that was ultimately decided by the appellate division, which was the issue of the court under 3032A, despite ordering the release with the electronic monitoring condition, nevertheless held the defendant in while that condition was being
Which the
implemented.
court shouldn't have done.
Should not have done, because under the language of 3030, which is very explicitly clear, does not speak
And do you
to
know
that.
whether that practice has ceased?
I'm unaware. I
Are
do
you
know-
aware of any instances where it has continued following your concession and here?
I am unaware, Your Honor.
So just so I'm clear, the other relief, any other relief sought that the appellate division ruled, I think, on the merits, that the other relief sought was meritless. Yes or no?
If that is the, I mean, it's a very short sentence that could be interpreted either way,
Well,
although
what's
here.
the other way? Is there possible that they're saying we're ruling on something that isn't before us?
It's, I mean, in my opponent's view, yes, that is their ruling, but again,
They
it
must
was
have
not-
thought that there was something in front of them that they needed to say they were denying.
Well,
Fair?
the issue, at the time of the appellate division, the issue of whether or not there was a live issue in that the defendant was subject to the monitor. So if the appellate division was accepting the defendant's arguments concerning whether electronic monitoring is release,
Right, but I mean, they think they were denying something on the merits. Is that fair?
I think that's a fair interpretation, yes.
Is there some other way to read that than they were denying something on the merits?
I don't think there's any other interpretation other that you can say that the defendant did not establish entitlement to relief sought because his argument in the first instance before the appellate division concerning the propriety of the imposition of the monitoring was not properly before them. So the
They
interpretation is.
usually will say something like not preserved, though, instead of not established the entitlement to, right?
I'm sorry, say that again?
They would usually cast that in terms of preservation or waiver or something like that, instead of hasn't established the entitlement to the relief.
It certainly could be written a
Okay.
much better
So
way.
Well, a different way, maybe.
A different way, a more explicit way, yes.
Okay. Other than the merits question of whether electronic monitoring is permitted, is there something else they could have been denying on the merits? Could it be, for example, the issue you conceded later?
Given the way that it's written, Your Honor, I don't think there could be any other issue because they did say, they ruled on the issue that it's moot, meaning the continued incarceration, and then not reviewing it, deciding not to review it as an exception to the mootness doctrine. So based on this very short response, I'm not sure there is anything else that they could be talking
Other than
about.
possibly the merits of electronic monitoring?
Correct.
Okay.
As to the merits of that issue,
I'm
you're-
sorry, I've
Oh.
lost it now. Are you saying that once they determined that that was moot, and they weren't going to vote the mootness exception to the mootness doctrine, they went to the merits anyway?
Well, I don't think, our position is that I don't believe that they did, because I think a fair interpretation of the decision of saying the defendant is not, and showed entitlement to relief sought, is because there was no proper argument for the court to review in the first instance. The appellate division did not have de novo review of this new argument that defendant was raising for the very first time before the appellate division in the writ.
Which was what? Just
Which
let's
was
go to it.
whether electronic monitoring was a permissible condition that the court could impose on a defendant released pursuant to 3032A. So as to the merits of that question, it is a statutorily authorized non-monetary condition of release under Section 500.10(3)AJ of the Criminal Procedure Law. And therefore, when looking at the language of 3032A at issue concerning release a defendant upon such conditions as may be just and reasonable, that was a condition that was available to the court and certainly appropriate in this instance, given factors that were laid out before the trial court concerning the seriousness of the crime, the defendant's criminal history, an incentive to flee, and so on.
Is it possible that the conditions attached to the assuming the electronic monitoring is permitted, is it possible the conditions could be so restrictive that it amounts to a lack of release?
No, Your Honor, because there are a lot of fundamental differences between, let's say, being incarcerated on Rikers Island and being limited, although restricted in movement and maybe bound to one's own home, that the inmates of Rikers Island, for example, do not have. So while a defendant under this most restrictive example of a home-based electronic monitoring still has the opportunity to eat and sleep and exercise whenever they want. They can order takeout and watch TV and have internet access and have access to a cell phone without those conversations being recorded and monitored. So in that sense, there are rights to privacy and other freedoms that do not exist in the limited environment of being, for example, on Rikers Island. So no, they would not be similar. And as to what the legislature spoke in this instance, in the language of 51044D, that is an exception to this otherwise general rule that not electronic monitoring in any of its forms is a non-monetary condition of release. It is considered by the legislature confinement in two and only two circumstances, neither of which are present here. If there are no further questions, the people will rest on our brief.
Thank you.
I believe there's an important distinction to draw between the phrase "released on her own recognizance," which is what 3032A requires, albeit under just and reasonable conditions, and the phrase "released under non-monetary conditions," which is referring to a specific list of conditions outlined elsewhere in the CPL. And 51010 sub 3 specifically draws that contrast. That statute says that if someone is charged with non-bail eligible offense, that person must be released on their own recognizance unless the court finds that that is insufficient to guarantee the defendant's return to court, in which case the court can impose from the list of that non-monetary condition. That very explicitly says, has the legislature saying that these are two separate things. And the legislature chose not to add the phrase non-monetary conditions into 3032A, which leaves us with the time immemorial reading of that statute, which requires the defendant's release. Prior to 2019, a defendant in Mr. Gibson's position would have been released on his own recognizance. There would have been no other option. And what the prosecution, what the respondents are asking this court to find is that the legislature, in reforms that were designed to decrease pre-trial incarceration, meant to impose additional options of restriction on the defendant who until then had been entitled to release. And there's just nothing in the legislative record to suggest that that was the intention, and there's nothing in the language that was purposely left out of 3032A that would have suggested such an intention.
Thank you.